Good day to you and welcome to another Paddocks Club video tutorial. An issue that comes up regularly is that of minutes. Now you know that minutes are the written and official record of the business transacted at a sectional title meeting, either a trustee meeting or a meeting of owners, and they're kept by the body corporate as a permanent record. Once they're confirmed by a majority vote at a subsequent meeting, they serve as evidence of what decisions were taken. Now, one of the complaints is that minutes tend to be very long. Well, it is true that it should not take you longer to write the minutes than it took you to have the meeting. And overall, the fundamental thing that you're supposed to be recording is the decisions made. You can, of course, include other detail, but the most important thing is simply an accurate text of each of the decisions made. Now, there's no common law requirement. It is in fact prescribed Management Rule 34 that specifically imposes a duty on the trustees to ensure that minutes are taken of their own meetings and those of the general meetings of owners, and they must be permanently kept. When any owner or a registered bondholder asks for them, the trustees have to make them available. That's 34.3. And also the managing agent must be given copies. That's 49.2. In practice, the managing agent normally prepares the draft minutes, gives them to the trustees for an initial check, and if they're minutes of any form of important meeting, those will then be circulated amongst owners. What should be in the minutes? Well, obviously it's going to start with a heading, and that tells you what type of meeting it is, the name of the body corporate, the place and the date. And when you start after that, there are a few preliminary issues, such as the name of the chairperson who chaired this meeting. And if during the course of the meeting the chair changes, then that should also be recorded. The persons who were present or represented should be recorded. It isn't always necessary to record apologies, but in some schemes that's the norm. I can't be there, but I send my apologies. You record that in the minutes. It's a matter of courtesy. The times at which the meeting opens and closes are normally included, and also, obviously, one of the first things that you might look at is the minutes of the previous meeting, and these can either be taken as read and confirmed, or they might be argued and finally approved by a majority decision before they're confirmed, but they must be confirmed, as I indicated earlier. It's normal also to number each issue. When you deal with exactly how do you record matters, the narrative, or you might say general things if you want to. The chairman confirmed that a quorum was present and declared the meeting open for business, but you don't have to say that sort of thing. That is the common law obligation of a chairperson. Whether you choose to take people through the detail, Mr. Sainsbury took the trustees through the financial report and drew specific attention to the arrear levies, this sort of thing. You might or might not choose to include that sort of thing. It's very much a matter of choice and of the particular culture of the body corporate concerned. But where a specific resolution is taken, where finances are approved, where the trustees are given a specific direction, it's really important that the actual wording be dealt with. And I think your consciousness should be applied to this during the course of the meeting. So you say, well, what are we going to record? What are the exact words? And that will then force the meeting to look specifically at the detail of what it's doing. So what you don't want is to include too much detail of anything that's particularly emotive. At the end of the day, the minutes should record those decisions which will guide the future management of the scheme. That's what's really important. Thank you for joining me in this short video tutorial. If you have any questions, let's deal with them in the discussion forum.